Good morning, ladies and gentlemen. My name is Iviwe, and today I'll be your facilitator for this workshop. I sit on the BMF Women Empowerment Desk on the BMF Gauteng and the national office, and the national structure. Today, I'd like to take this time to welcome our Deputy President, Ms. Tasneem Fredericks, who's also the champion of BMF Women Empowerment Desk. I'd like to take this time to welcome Gopi, who's the head of research at the BMF. She will take whatever we're discussing here, translate it into a policy position of the BMF. Riola, a warm welcome to you as well, who'll be taking us through this code today. To the members who are watching at home, welcome again. We would like to encourage you to give your comments on the comments side. And also if you have a question, there's a Q&A button at the bottom. Please use that. Whatever inputs that we are having today, they will be translated into a policy position of the BMF. So the Minister of Employment and Labor, Mr. Thulas Nxesi, recently published the draft code of good practice on the prevention and elimination of violence and harassment in the world of work. In terms of the Employment Equity Act 55 of 1998, and on the advice of the Commission for Employment Equity. The draft code is aimed at addressing the prevention, elimination, and management of violence and harassment that pervade the world of work. This policy aims to ensure full alignment with the ILO Convention regarding ending violence and harassment in the world of work. Gender-based violence is an issue requiring systematic transformation, which can be greatly influenced by our various social structures and crucial structure for such change in the workplace. The BMF is hosting this workshop so that we can have the comment on the draft code. The purpose of this workshop is to help our members to better understand this draft code, hear views from the BMF members, and consolidate all the views and inputs for a BMF submission to the Department of Employment and Labor. So Riola will be taking us through this draft code, and again, please do put in your comments. And to formally welcome us, I'd like to ask our Deputy President, Ms. Tasneem Fredericks, to do opening remarks.
Thank you so much, Iviwe, and welcome to Riola and all our participants. I think it's important that we're having this conversation because I think we can all agree, in fact, I know that we can all agree that this is a code of good practice that's going to form part of the Labour Relations Act, and it's long overdue. It speaks to specifics around ending harassment and sexual violence. It goes into details in terms of, definitions. And I think I'm not going to go too much into that. Riola will take us through that. I just want to mention that South Africa is a member of the International Labour Organization. And even though it has not adopted Convention 190 yet, what that ILO Convention 190 does is it recognizes the right of everyone to a world of work free from violence and harassment, including gender-based violence and harassment. So I hope that there are men that are part of the participants. I often get BMF men saying, but DP, what about us? So I think it's important to acknowledge that this is a gender-based code of conduct, and it applies equally to both males and females. And I'm not going to go really into the details but it does include the LGBTQIA+. I hope I'm getting that right. It's for everyone. That's basically what I want to say. And I think South Africa needs to adopt this. We need to lobby our government. In January this year, Uruguay was the first country in the world to ratify the ILO's Convention 190, which recognizes that violence and harassment at work constitutes a human rights violation. So this is an important point. The fact that we have drafted, or the government has drafted a code in August 2020, means that we agree as South Africans with this convention. And I think it also addresses issues in the form of new forms of bullying, like through online channels. I mean, there's now cyber bullying. Violence and harassment is now no longer just physical. It includes psychological and emotional abuse, which I think is something that, you know, as a woman myself, I've grappled with that, you know, this kind of, where you almost feel like it's imaginary, that you're imagining this harassment because it's not something that you can physically show to someone else. And then I think another important point just to mention in opening is to say that the new code will also apply to the informal sector. So it extends beyond corporate. And I'm hoping that Riola will talk to that, because we've got a lot of SMME members. We've got a lot of members who work, you know, not a lot, but there are members that work in the informal space. So I think it's important that we highlight that. And then just to say that, you know, according to the code, you know, to the code in the Labour Relations Act and the Occupational Health and Safety Act, violence is a form of misconduct. So this means that you can be fired for, if you ever, you know, through a disciplinary process, you know, you get found wanting in terms of your behavior as an employee towards another employee. And also it puts really a kind of onus on the employer to protect an employee who raises violence and harassment in the workplace. I think the objective of the BMF's workshop is mainly, you know, we are an advocacy and lobby organization. So we want to solicit our own comment to the draft code to the Department of Labour. I believe the closing date is on the 21st of October. So I think members really need to, this should really have been workshopped at branches. And I'm hoping that through the participants that are online today, these discussions have happened, or you know, we also want to take it further in terms of making submissions, but then doing an online survey to really get to the heart of, you know, eliminating violence and harassment in the workplace, because it's very crucial that, you know, we really take concrete steps towards eliminating gender-based violence. So without further ado, Iviwe, I'm going to stop there and allow the program to continue. And I think maybe just for you to take us further in terms of the program.
Okay, thank you so much, Deputy President, for those welcoming remarks. So we are, we did start 5 minutes late, and we would promise that we would keep this within an hour. So I am going to ask at this point Riola to project her presentation. We'll be taking questions as we go. So Riola will have intervals. So when it's interval time, I will be then taking questions from the floor. So please do type in the meantime. And when we're taking those questions, I will read out the questions to Riola. Riola, are you ready for us?
Yes, thank you, Iviwe, I am.
Welcome. Go ahead.
Thank you, everyone. Just by way of introduction, my name is Riola Koch, and I am the professional support lawyer and knowledge expert of the Cliff Decker Hofmeyer employment practice. Now, I think very importantly upfront, I would like to make a disclaimer. I am not a harassment and I'm not an expert in harassment or sexual violence, etc., but I rather speak as a lawyer, looking at the draft code from a legal perspective, from an HR perspective, and then from a capacity perspective as well, both in terms of the department, but also employer capacity. So what we're going to do, and if we're going to keep it to an hour, I'm not going to necessarily read out everything on the slides, but give you a high-level overview of the substantive content of the draft code, and then looking at more procedural aspects around reporting, employer requirements in relation to the creation of training programs, policies, etc., and what needs to be taken into consideration there. What I think is important when we look at the code is I want to set a particular backdrop. So the first is that of COVID-19 and the economic recession. What research has shown is that whenever there's economic recession, there's an increase in sexual violence and there's an increase of sexual harassment in the workplace. And the reason being, at least what experts say, is that people are looking for other forms of power as they lack economic power, and so they look for forms of power in the forms of sexual power, either in the workplace, particularly in relation to people who may be more junior than them. What we do know is that sexual violence and harassment also works on power dynamics. And so while not necessarily exclusively, but largely it is from the perpetrator is generally in a more senior position, and the survivor of the abuse is generally someone in a more junior position. Now, what we must take into account when looking at the code is also the job security issue currently in the particular circumstances, with people being very concerned about either not having jobs or retrenchments that are ongoing in various sectors of our economy at the moment, and that places people at specific risk for sexual violence and harassment. The other things that I want to say just broadly in terms of a background is we must look at the code in terms of understanding the shame that is attached to sexual violence for survivors of sexual violence, victim blaming, identity and confidentiality issues, but also we must look at the issue of re-traumatization of the survivor through the process, whether it be formal or informal. And so when looking at the code, I think one must use these as a lens. The last opening remark that I'd like to make is exactly the issue that Tasneem touched on around the employer. So the employer is obviously very broadly defined, and it includes both large-scale employers, so from JSE listed companies, right down to a small business where there are only 3 people. Now, what becomes an issue is that what we see is that often in very small organizations, the person that you are reporting to, the employer, the HR personnel, the perpetrator is very often all the same person. Now, what we don't find in the code, unfortunately, is that what mechanisms are provided for very small businesses where the perpetrator, the employer, the HR personnel, to whom the person who's drafting the policy, etc., are all one and the same person. Now, obviously, you can refer your matter to the CCMA, which is a formal procedure. However, what we find is that there's no informal procedure for very small businesses, but that's something that I'll raise when we get there. What we do need to look at is this code in the context of the existing legislative framework, and that's the Constitution, the Employment Equity Act, sections of the LRA, including sections related. So just to say that that's the existing framework. It's obviously the Constitution as the head, being the prohibition on unfair discrimination, a similar provision that's found in Section 6 of the Employment Equity Act, and then the provisions of the LRA, which speak to automatically unfair dismissals related to, for example, making a protected disclosure, as well as unfair labor practices in relation to demotion, promotion, performance related, etc. Now, what the code does is that it gives 3 broad categories of violence and then 4 different types of violence that it particularly looks at. So the first is self-directed violence, and this is violence against oneself, and it includes suicide or suicidal thoughts or anything of that nature, or any self-abuse, which includes self-mutilation, etc. And there is a duty on the employer to also educate employees around this, but also to put strategies in place in order to deal with this. Then there's interpersonal violence against one another. And again, here, very particularly, like I said, what we often find, although not exclusively, is that the power dynamics of senior versus junior often play out in interpersonal violence. And then there also may be collective violence or community violence, where a group that identifies themselves, and this is not necessarily race-based or even gender-based or sex-based, but it may also be a group, for example, in a strike context, where a group identifies themselves as striking employees and inflicts violence against employees who have exercised their right not to strike. And this is a very, can I just, being a labor law lawyer, I must say that the collective violence issue, particularly around strikes, of course, violence against persons has always been prohibited, but the fact that an employer now needs to take very special measures, particularly in the context of a strike, to protect non-striking employees is a welcome move for non-striking employees who may wish to exercise that right. Then very broadly, it's sexual violence and harassment, which includes domestic violence issues and domestic violence very broadly being both psychosocial, physical, emotional, financial abuse is also included. And then racial, ethnic, or social origin violence, which speaks for itself, workplace bullying, which I will spend some time on. Particularly what's interesting about workplace bullying is that there's a very broad definition of the workplace, in that the workplace is no longer limited to the physical premises of the employer, but is much larger, in that even social events that one attends within the course and scope of their employment is included, where you're traveling for work purposes, where you perhaps attending a off-site training session and the like, whether you are during office hours or meal times or tea breaks, etc., is still considered, where it's in the course and scope of your employment, of course, is considered workplace bullying. And then workplace harassment on the account of protected disclosures. Now, just to look at violence and harassment as the first category, it includes both sexual harassment, racial harassment, harassment related to parental responsibility, as well as gender and gender-based violence. Now, there's something I want to say quite particularly about the parental responsibility. If you look at the definition that's included in the Act, and I just want to get the particular, so if you go to section 6 and you look at the definition, surrogacy is included, paternity leave, maternity leave is included, as well as parental responsibility. What is not specifically stated in the definition in relation to harassment related to parental responsibility is adoption leave. And when we look at the law in relation to the interpretation of statutes, there is in fact a rule that says that where it's not specifically stated, but other categories are stated, then one assumes that the intention of the legislator was to specifically leave that out. And so I think that there is a gap there in relation to that definition. I just want to find it, or I'll give you the reference. But that is something that I think needs to be specifically stated, because all other forms of leave in relation to either the adoption of a child or commissioning parents, etc., is included. Sorry, not the adoption of a child, but giving birth to a child, or where someone has had a child through surrogacy is included. But are there any chances the submission date could be extended? We only have about 5 days to go to the submission date, and nothing has been said in relation to an extension at the moment. And so we must assume that we are proceeding on the date that was intended. So the date stipulated in the draft code is 60 days from the date of the publication, and the draft code was published on the 20th of August. Then on the issue of gender and gender-based violence, it's both within the workplace, but one can also report violence that takes place in the home. And then workplace bullying, it's considered a form of violence and harassment, and it's a violation of your right to dignity. Now, previously, bullying was really looked at as or workplace bullying and harassment was looked at as a deprivation of a benefit. So often where one was either not promoted, or they were not given a salary increase, or your performance appraisal perhaps did not align with your performance for the preceding year. What the code does is that it takes it away from a particular benefit. You no longer need to allege or bullying in relation to either not receiving a promotion, etc. But it's really about the deprivation of your right to dignity. And so it's a far broader categorization of harassment, and a much welcome categorization of harassment, because often, for example, there may be employees who are not eligible for promotion within a 3 to 5 year period. And obviously harassment may take place in that period. So where it's linked to a benefit in relation to salary increases, which are often discretionary, or a promotion that you may only be eligible for in a number of years, then it makes it very hard to an employee to claim bullying in that respect. So here, the bullying is a lot wider than what was ordinarily considered. And it's actually about a violation or deprivation of your right to dignity as opposed to a workplace benefit. Then when we look at forms of violence and harassment, it includes both physical assault, discrimination, gender-based violence, like I said, and gender-based violence is not necessarily, or sometimes it's thought of as violence against women, but gender-based violence is violence for against the LGBTQIA+ community as well, or any violence that is inflicted upon you for deviating from any heterosexual norms. Now, it's important that the code also recognizes that employees who work with clients or members of the public are specifically exposed to further violence from members of the public or their clients. What we know about the existing provisions of the Employment Equity Act is that an employer cannot be, and there's case law to this effect. So there's a case in Cape Town, and I will forward the citation, but there was a case in Cape Town where a client of the employer called the cashier of the, or the employee of the employer, the K word. The employer could not be held responsible for the behavior of the client, and therefore the employee was only left with recourse in relation to a civil rights remedy, which they needed to institute in the High Court, which, as we know, is extremely expensive. This code, and is quite a good move in that regard, is that it does hold employers to some extent liable for the actions of the public as well as their clients, and calls upon employers to take more positive steps in relation to the prevention of violence in relation to their employees, irrespective of whether that violence is inflicted by another employee or the employer themselves, but also but really calls for the protection of workers, I think, who are exposed to members of the public and who may just not have the fees to litigate against the public in that regard. And then, of course, domestic violence and harassment, which I'd like to look at very closely later on, particularly because we know that South Africa has a huge domestic violence problem. We know that the police were supposed to be trained in the Domestic Violence Act is not equipped to handle cases of domestic violence. And I want to interrogate whether or not the code makes specific provision or the requisite provision for HR personnel, in fact, to deal with issues of domestic violence and harassment. And then what's important, I think, in terms of sexual violence and harassment is that it really also includes a hostile working environment. And like I said earlier, it's that it's removing harassment away from a particular or denial of a particular benefit, but rather linking it actually to the right to dignity, because that's really the heart of discrimination. And the Constitutional Court has said this a number of times, the heart of really a violation of one's dignity is what is actually the essence of discrimination. Now, harassment is unwelcome conduct that makes you that makes the person uncomfortable and interferes with them being able to do their work. Now, unwelcome conduct is either conduct that the perpetrator has been told, or the alleged perpetrator has been told, that the conduct is unwelcomed. And this, what the code specifically says, that where the conduct was previously welcomed, it does not mean that in this particular instance that the conduct is welcomed. What the code also does is that it says one doesn't need to have repetitive behavior for it to constitute harassment, that a single incident is sufficient, and that again is welcome, because often perpetrators of violence are quite careful as to, or are very systematic in the manner in which they do it. But also one doesn't want the situation to extend so far that the employee is obviously sometimes rendered physically incapacitated to even make a report. What I do want to look at critically is this idea of harassment being looked at. The test for harassment is this: the subjective feelings of a person must be registered against what is objectively, and I use that inverted commas, of the reasonable person. So the factors to consider again is the unwelcome conduct, the nature and the extent of the conduct, and the impact that the conduct has on a person's ability to work. It must be persistent, although a single incident is may be sufficient to constitute. The complainant is offended and has notified the perpetrator of the behavior. very importantly, and what I think is welcomed in the code, is that where a complainant does not feel specifically comfortable to report to the to the perpetrator rather, that their behavior is unwelcomed, the complainant may do so either through another employee, through the employer, or they may even do so through a member that is a family or a friend that could inform the perpetrator that indeed the behavior is not welcomed. The second aspect is that where the person should know or knows or ought to have known that the behavior is unwelcome, then it is not necessary for the survivor of the sexual harassment or other forms of harassment to actually have let or the complainant rather, to have let them know. Now, the Act doesn't say what does it mean for one to know or ought to have known, and this seems to be quite a gray area. Now, what we must remember in relation to sexual violence or any form of harassment and violence in the workplace is that this idea that subjective feelings of a person is going to be measured against an objective standard of the reasonable person. This must be quantified in relation to cultural and social beliefs, where what may be acceptable in one culture is not necessarily acceptable in another culture. For example, certain cultures, to look someone in the eye is actually a sign of disrespect, whereas in other cultures, it's a good sign of assertiveness and the like. And so where one is comparing, and the legal test of the reasonable person is arguably actually a very Western idea, a very male-centric idea, and doesn't necessarily take into account issues around sexual violence. One, in that violence is often very subtle and may not necessarily be, was very often or never overt, or in very few instances it's very overt. And so what the reasonable person is expected to feel in a particular circumstance, or how a reasonable person is supposed to understand or understand the violence, really is very different from culture to culture based on what is and is not acceptable norms in different cultures. And I think that the reasonable person standard as something to measure subjective feelings by may perhaps need to be further qualified, in my opinion, in this code, because the reasonable person is a bit far too, it's far too vague a concept to measure feelings, particularly in a very diverse society like South Africa. And therefore, I think that the position of the responsible or the reasonable person as an objective standard must further be qualified in the Act. And the Act must say, taking into account specific cultural and social norms of both the complainant as well as the perpetrator. And then racial violence, again, it's unwanted conduct. It may be persistent or a single event. And again, it is linked to demeaning or humiliating or creating a hostile environment, direct or indirect behavior, racist jokes, memes, very importantly, because I think often now that we're moving to the digital age, often a lot is communicated via pictures and the like. And I think it's very important that memes and the like are also taken into account, because I think these are by far more subtle forms of violence, and often violence can be masked as being either humorous or intended to be humorous, when actually it's meant to terrorize the person to whom it's being sent to. And then workplace bullying, it includes both physical, verbal, or psychological acts. It can include slandering or maligning, deliberately supplying incorrect information to someone, not answering their emails, for example, could also be an example of that, demotion without justification, and abuse of disciplinary proceedings where vexatious charges are brought against someone even though there's no basis for it. And now the factors to be considered in workplace bullying is interpersonal conflict, aggressive behavior, sociological violence, harassment, and disclosure of information. Now, the last form of violence that I want to look at very closely is violence in related to, or harassment in relation to the making protected disclosures. Now, very importantly, a protected disclosure must comply with the the policies of the employer in order to be afforded protection under the code. And whether the information, in fact, could be disclosed in terms of the Protection of Disclosure of Information Act, and then the remedies that are, and then the third stage is to ask, has the employee been subjected to occupational detriment? Now, what's important is occupational detriment needs to, again, in my view, be further defined. Occupational detriment can not only mean where an employee has either not been denied promotion, etc., but occupational detriment should also include the psychosocial effects that an employee suffers in relation to the making of these disclosures. Now, remember, disclosure is only protected provided that it complies with the policies and the procedures of the employer. And this is again problematic in that if the policies and the procedures of the employer do not comply with the Act, or whether the policies and the procedures of the employer do not make for sufficient protection of the employee, it again places the employee who's made this disclosure in a particularly vulnerable position. And then just to look at the prevention and elimination of workplace, we know that section 60 of the EEA says that, and I think I'll stop here, in fact, to take questions and also to have a discussion before we actually go into policies and procedures around the forms of violence that are incorporated. What I think I maybe have not sufficiently emphasized is that any cyberbullying or anything that takes place on the net is also constitutes forms of violence. And so in a work from home situation, which we often find ourselves in now with COVID-19, it's not to be understated that this code will apply in work from home situations. And so that is also a welcome move, of course. If I'm not sure if there's any question.
Thank you, Riola. There aren't any questions so far. If you have a question or if you have a comment, please just insert it. Riola, I am, however, interested when we talk about cultural beliefs, especially in a country like ours, where even, I'm assuming our law then takes, as you said, takes the approach of the West, of the Western, and the country on its own is very complex. We're facing really complex cultural differences. So a reasonable person, how do we then find a position that will speak to the cultural norms and beliefs of South Africa, as complex as it can be? Because I think it's very, very, very vague and very, who gets to decide the reasonable person? Are we using standards of British or whoever? How do we then translate to a South African cultural norms and values?
Yeah, and this is why I think it's important, Iviwe, for the code to be qualified to say the following. It must be, tested against the objective standard of the reasonable person, comma, taking into account the cultural and social beliefs of the individual person. And now when we talk about cultural and social beliefs of a person, this is where employers must actually get experts in. You must speak to people of the particular culture, etc. We cannot have blanket approaches either in legislation, particularly of this nature that deals with violence and even sexual violence, where we're making blanket approaches about what is and is not reasonable. So for example, one may think it is reasonable to put their hand on an employee's shoulder, and in some cultures, touch is completely acceptable, whereas in other cultures, looking at someone in the eye is a sign of disrespect. And so while the subjective feelings must be objectively assessed against a reasonable person. For example, the reasonable person in a corporate environment means what? Does that mean that in corporate environments we do touch each other's shoulders? In corporate environments, a handshake is something, you know, that's standard, for example, but that may not necessarily align with cultural beliefs. And so I do think that a qualification must be made in relation to this reasonable person. It cannot be a blanket standard of what is and is not reasonable, but what is and is not reasonable should be should be looked at in the context of cultural norms of both of the complainant, really, because the complainant is the one that's going to voice that they are indeed uncomfortable.
Okay, thank you for that.
And I think that's the problem. Sorry, Viva, just to say, this is the problem with sexual violence more generally, is that people think that we can either, we're always explaining it away by, oh, it was just this, oh, it was just that. And that's what we do find often in cases of sexual violence, but or any violence, really. But the problem is that really it's actually what constitutes harassment or violence is how the complainant actually feels, how it makes them feel. So me putting my hand on your shoulder may not make you uncomfortable, but it may make the next person uncomfortable. And that must not be overlooked by this idea that it's only reasonable to expect someone to put their hand on your shoulder, for example.
Oh, thank you for that, Riola. I have a question here, and it says, I'll read it out. So what is the timeline in terms of when you can report harassment? So, for example, can you complain a year after the event?
So what the code does say, and I'll get to that on the procedural aspects, it says immediately. Now, immediately is as soon as reasonably practicable afterwards. Now, again, that's something that I think we must discuss is quite problematic. Firstly, the word immediately should be deleted in its entirety. Because it's too onerous a thing to do. One, because of the trauma that's related to violence and harassment more generally. One doesn't feel comfortable to come forward immediately to express this. Often one does need to confer with one's family or a friendship circle, or in fact seek some kind of support before coming to the employer. So for the code to say that one must do it immediately, and then it says after that, the next paragraph says that, well, immediately means as soon as practically possible. As soon as practically possible, again, is again too vague as to what is as soon as practically possible. So the timeline in the code, there is no timeline. That's the first thing. The second thing is that this onus on the complainant coming forth as soon as practically possible or immediately may not necessarily be it's simply not practical. Often what we find with violence is that where someone comes forward, then you have 10 more complainants coming forward to say, this actually also happened to me a year ago. This also happened to me 2 years ago. And then what we find in these situations is that those people's testimony is either disregarded or they're rendered not credible witnesses on the basis that they took too long to come forward. But then that doesn't take into account that violence and harassment is laden with trauma. So this idea that one must report immediately or as soon as practically possible, I think is completely, it's impractical. It doesn't take into account the idea that the trauma that's associated with violence. And I think that that's something that is highly problematic and must be relooked at.
Yeah, thank you, Riola. I think I can agree with that, because when the abuse happens, how are you comfortable to go forward? Some people take a month, some people will take a year. So I definitely agree when you say the word immediately becomes problematic. I have another question for you from Sandy.
Yes.
Sandy says, thanks Riola for this presentation. I am interested to know if the negligent misstatement would also be included in the broad definition of violence. My view is that your manager gives you a bad reference without justification. It is an abuse of power that should be included here. What is your view?
Yes, I agree with that. And I actually think that recommendations become a mechanism by which to victimize employees. So one, and like I say, because of the nature of violence being obviously senior against junior, one finds that people don't want to come forward either because they know they're moving into another job, etc., and they want a good reference. And we can't have references being used as a mechanism by which to actually silence people, both by way of an upcoming promotion or perhaps even moving employers. So yes, I do think that it should be included in the form of violence. And then again, when we look at very small employers, that becomes of particular importance, because like I say, the perpetrator, the employer, the reference giver, the person to whom you're supposed to report is often all the same person. And that's quite a scary situation. And there, an employee is almost forced to go a more formal route by approaching the CCMA, even if they actually wish to do an informal approach where you actually just sit down and you discuss it. Of course, one can do that through conciliation at the CCMA as opposed to an arbitration, but one may not want to actually approach the CCMA and have an external person in the room. So where it's very small businesses, the commission actually needs to look at whether or not you're going to be able to approach the commission for assistance in this regard, or are they going to supply somebody who's, you know, sufficiently equipped and the like. And I think that's something the commission must look at.
Okay. All right. Thank you, Riola. I'm happy for you to go to the next slides.
Sure. Now we're just going to deal with some procedural issues and then we'll raise them. I know we only have about 10-15 minutes. But let's just talk, I won't talk about the interplay between section 60. I will share this presentation with you, so if you'd like to look at things in more detail. But what employers are required to do is a policy on sexual harassment and violence in the workplace, and it needs to really include the following. So the forms of undiscrimination that are, unfair discrimination rather, that are not permitted in the workplace, the procedure for a complainant to lodge a complaint as an employee or even as a non-worker, and procedures to be followed by the HR department to investigate the complaint. Now, what we see here is that the code does not say by when a policy must be in place. And I do think that it's really important for the code to specifically state two things. One, the time frame in which a policy must be created as soon as this code is promulgated. And the second thing is that how employers need to periodically update these policies is also very necessary as we learn more about harassment and violence in the workplace and what does and does not work. I also think that there should be some kind of oversight mechanism in relation to these policies. And so the policies should be submitted to the Commission for approval. The nature of the information and the nature of the subject matter of the policy is such that it is incredibly sensitive. And I don't think that it is a policy that employers should be left to their own devices to make without any oversight mechanisms in place. And that's my particular view when we look at the nature of the subject that we're dealing with. And so I think the Commission needs to play a more robust role in the policies that employers are in fact creating. And then just to say, the employer needs to also have protection and a awareness policies. Protection and awareness programs. What we do find is that policies are great, but one must actually train employees, because I think that there needs to be almost a reworking of how we think about the workplace, reworking how we think about gender. Of course, the employers can't be responsible for socializing the population, but they do have a role to play in at least socializing their workforce on what is and is not acceptable. And so just to tell you what these awareness programs need to incorporate is mitigation measures that are in the workplace, ongoing monitoring and evaluation of whether or not it's working, to incorporate training on workers and prevention measures, to grant access to information, but also access to counseling. And what I think the code does need to do is also, where an employer cannot afford counseling, that the code needs to specifically state that other measures must be put in place, or employees must be referred to either pro bono organizations or government organizations where they indeed can receive this counseling. Now, the protection and awareness programs, again, not stipulated how often these programs must take place, how often they must be updated, when they need to take place. And I think that this is something that needs to happen maybe even at least on a biannual basis, perhaps even 4 times a year, taking into account South Africa's specific circumstances in relation to violence and harassment and gender-based violence, even in the world of work. And so I think that the code needs to go further. It cannot say that we have to have prevention and protection programs, but it must actually stipulate to the employer that these must be run X number of times a year. It must be mandatory for it to be in all new joiner training, so that you know that the people coming into your organization are aware of the norms, they're aware of the policies, and therefore where there's a contravention, they cannot raise ignorance as an excuse. And so the code is deficient in those regards. It doesn't say how often these programs must take place. It doesn't say what these programs, so it broadly outlines what the programs need to include, but we do need to actually place a burden on employers to make sure that they do it periodically and not as a one-off tick box exercise. Then employee dispute resolution, I'm not going to go into that. Other categories of affected persons, just to say that where you are perhaps not an employee and you cannot necessarily raise your disputes in relation to the Employment Equity Act, the Labour Relations Act, or even the Occupational Health and Safety Act, you may always do so in terms of PEPUDA or whistleblowers, and that is allowed. The code also takes into account wellness programs or treatment programs for persons who are affected by harassment and violence in the workplace. And like I say, for very small employers where they may not necessarily have the means to do so, I think that they must be referred to particular organizations, etc. Very importantly is the privacy and consent, and the issues related to POPI in that regard, and the protection of personal information, as well as the confidentiality of a complainant who does not wish for their identity to be disclosed. The code does mention this, but I don't think that there are sufficient safeguards built into the actual code for people who wish for their identity not to be disclosed. And I think that there must be more particular solutions provided to employers in this regard. For example, we must take measures to perhaps move the employee to a different department, etc. And I don't think the code necessarily speaks to issues around those kind of measures to be taking place. So the code speaks to counseling, it speaks to internal policies, it speaks to training and wellness programs, but I think there aren't sufficient intervention mechanisms for employees who are in fact facing the violence. Like, can an employee elect, for example, to be placed in another department? Can they elect to, and very importantly, and I'll speak about this when we come to the informal and formal process, can an employee elect to give evidence in camera as opposed to being in the same room as the perpetrator? Now, in law, one is allowed to make an application, which may or may not be denied by the employer, to give in camera evidence. But I think that this is something that the code should make very explicit, that an employee may by election actually give in-camera evidence and choose not to be in the same room as the perpetrator. But I'll come to that in the informal and formal process and just reiterate that point. But just to say, treatment, care, and support programs must be provided. We must ensure that there's no discrimination for people coming forward and the like. But I will skip wellness programs to maybe just talk a little bit around strategy. So the employer obligations, so an employee must immediately, like I say, report the violence or as soon as practically after. And an employer must then consult and confirm with all the relevant parties. They must interview the relevant parties. They must question the relevant parties and seek information from the relevant parties. Now, where a perpetrator of sexual violence or any violence and harassment in the workplace is perhaps only harassing a particular individual, there may be an issue where an employer starts consulting or questioning or interviewing that relevant party. The code does not speak to what happens then to the person or the complainant at that particular point. And I do think that certain safeguards must be built into the code around this. So where a person comes forward and we are now in the interview process and the questioning of all relevant parties, the employer must make certain protections available to the person who has come forward. Otherwise, it really does, one, it dissuades the person from taking the process any forward or any further, simply because one is already facing harassment simply at the initial reporting stage. And so I think explicit safeguards must be made available in the code in relation to this. But that's an employer's obligation once it has been reported. And then very quickly, so there's an informal process that an employee may elect to follow, and then there's a more formal process that the employee may follow. The informal process is really that a complainant or any other appropriate person basically explains that the conduct is not welcome, that it is offensive, that the conduct makes them feel uncomfortable, and it affects their ability to work. And it's really asking the perpetrator or the alleged perpetrator to desist from the conduct. Now, this obviously can be together with HR personnel and the required persons, etc., to have this sort of sit-in meeting. An employer then still has an election, even if the complainant chooses to go through an informal process by which that is their right to choose a more informal process. The employer still has an election to go ahead with any measures that they may seem necessary in terms of their own individual disciplinary code and procedure. Now, this means that you may still, irrespective of the fact that the complainant the complainant has elected not to pursue it in a formal proceeding, the employer may pursue it formally. Now, what the code must make very, very clear, I think, is that the complainant cannot be forced or subpoenaed or otherwise to be a witness to any formal proceedings where they have chosen to go through an informal process. And like I said at the beginning, that is one of the considerations one must have when we're managing violence and harassment, is that often the reporting process or the prosecution process, if I can say, but that's too formal a word, but a prosecution process can often be very re-traumatizing to a complainant or a survivor of violence. And so what the code must make very clear is that the complainant cannot, unless obviously it's criminal proceedings, that's a different matter altogether, but then the complainant would need to make the complaint. But the complainant cannot be forced to go through the employer's formal procedure where they have chosen to go through an informal process, simply because one cannot, through the code, actually be re-traumatizing complainants. And then there are more. Yes, sorry, Ingrid.
Viola, just a quick one whilst we're on that. Nosita is asking if Nosita is asking if one's boss does nothing about the reporting of abuse and harassment, what should the victim do?
At the same time, avoid the victimization. So one doesn't have to one doesn't have to report directly to one's boss. So the code is very wide in that it says any HR personnel or the employer. Now the employers, well, depending on the nature of the organization, can be quite a broad term. As it can include anybody in management, it can include HR personnel, it can include perhaps even if I know that some employers even do have, for example, industrial psychologists. So it includes various persons, so one doesn't necessarily have to report to their line manager, for example, particularly because the line manager may in fact be the perpetrator. So so one doesn't have to do that. The code doesn't require you to do that. And then I see Terry also has a question. What is the reasonable thing to do? Okay.
Terry has a question. Yes. And Terry is asking, what is the reasonable thing to do in cases where one feels abuse? Is it to inform the perpetrator about your uncomfortability first, or go for serious report immediately? Because an individual might not be aware that they are actually offending the other.
No, so it is to go immediately and to report it. I wouldn't. So one doesn't know how the person against whom you're alleging harassment or violence is going to react. And so the code doesn't require that you speak to them directly. What the code does require, however, in a later section is that where the violence or harassment is of a serious nature, that the complainant directly reported to the employer as opposed to reporting it either through a colleague or a friend or a family member. And I think that's where the code goes wrong. Where violence or harassment is of a particularly serious nature, it's more so that a complainant does not feel comfortable to directly report. And so the code doesn't say that you must report it where it's serious, you must directly report it, but it says that you are encouraged to do so. And I think that should be removed, because encouraged to do so means how is an employer going to implement that in their particular workplace may become problematic. And I think the more serious the violence, the more unlikely, in fact, one is to come forward to report. And so it's for a complainant to then be encouraged to report it directly where it's serious, I think is too onerous. And again, doesn't take into account the nature of abuse, the trauma involved, the shame also that's involved, because often persons who are either complainants of violence and harassment often feel like it's their fault. And so to encourage one to report it directly where it's of a serious nature, I think is misguided. If you would, do you mind if I continue, and then we'll take the rest of the questions at the end?
You may continue, and then we'll just close with the last questions.
Okay. And then there's a more formal procedure. Now, the more formal procedure will really follow whatever the policy of the employer is in place, but also it may go to the CCMA, it may result in disciplinary proceedings, and then timeframes which allow the complaint to be dealt with expeditiously. And it's obviously an offense to retaliate against a complainant who lodges a complaint, provided, of course, that the complaint is made in good faith, and that the complaint is not vexatious or false. And again, with the formal procedure, the good thing that the code does take into account, which often we don't see in other policies and procedures, is that one may follow an informal process and later follow a formal process. So one may think that mediation is the way you want to go and you want to deal with it through a round table, but you don't then negate your right to follow a more formal process thereafter. And I think that's a welcome move by the code, because one often doesn't feel like initially that they want to take on a formal process. So they go to the informal process, and then they either realize that the perpetrator is either not remorseful, or they realize that in fact they would like to follow a formal process and they are open to do so. But like I say, when an employer chooses to go forward with a formal formal process, notwithstanding the complainant wanting to do an informal process, it must be very blatantly or very clearly stated in the code that the complainant will then elect to be involved in that process in any which way they choose. And the second thing that I think must be made explicit is that a complainant must be allowed to make the election to give evidence in camera and not be forced to be in the same room as the perpetrator of the violence. And I don't think that that must be an application that needs to be made. I simply think that that must be an election. And it speaks to the age that we're in. I mean, we're running full court trials now over Zoom. So there's those whole old-fashioned ideas around, like, you know, testing the credibility of the witness and the like in person have all fallen away. We've now realized that that's not necessary, and that one can do exactly the same thing over a video conferencing call. And so I do think that must be made specifically stated, because like I say, one of the things that this code must be very mindful of is the re-traumatization of complainants once they have complained, but also when they're going through either a formal or informal procedure. The last point I want to make is around the persons who are responsible for this code. Now, in the employer organization, like I say, in very small organizations, unfortunately, it may also be the perpetrator that is responsible for the monitoring and the evaluation of this code, and that's problematic. But what's also problematic is that the code deals with very broad issues of violence around sexual violence, domestic violence, and the like, and whether or not HR personnel are in fact equipped to deal with these issues of violence when we have a police force who are trained in the Domestic Violence Act and yet fail to do so is again something that's problematic. The code does not make any mention of the Department of Employment Equity to in fact, or the Commission for Employment Equity to go on a roadshow, for example, to make sure that HR personnel are in fact equipped. There's no training program that's provided by the Commission, and that must be specifically mentioned in the Act, I think, because one of the things that we find is that People are then re-traumatized by coming forward. It dissuades everybody else from coming forward. And then we're still left with an issue of violence and harassment in the workplace because we don't have people who are professionally trained to deal with this. And in smaller organizations where the employer simply does not have the resources to have employees trained, there must be some measures that are put in place by the Commission to ensure some basic standard is in place. And that we don't see set out in the code. And I guess that's my closing remark, and I'll take questions.
All right, I have one last question, Riola, and then we'll close. This is from Vanessa, and she's asking, is the workplace bullying currently in the Labor Relations Act or it's a new phenomena?
So the current code on harassment in the workplace does include this idea of workplace bullying. But the one that we have now, which includes cyberbullying, for example, again, like I said previously, bullying was in relation and harassment was in relation to a benefit. So you could claim bullying where you were denied a promotion, unduly denied a promotion, unduly denied an increase, etc. Now what this code does, and that is a welcome move, is to say that it's got nothing to do with the benefits. If you deny someone the right to dignity, that constitutes bullying. Whether it's in person or not, whether it's physical or not, it can still be bullying. You can be sitting in, I don't know, the UK, for example, and I'm sitting in South Africa, and it can still constitute bullying where, for example, you are forcing me on work calls at certain times, you're demoting me where it's not required, or you're saying things that are, and again, malicious languages even constitutes bullying. And that's got nothing to do with job titles, movements up the job ladder, etc., which I think previously bullying was always linked to those aspects. Now it's a lot broader. And I think that's very good because often these things are far more subtle than being denied a promotion. You know, it's the subtle comments that are made in meetings. It's the humiliation in front of clients. Those are the forms of bullying that we actually need to address because like I say, sometimes you're only eligible for promotion every 3 years. And what do you do in the interim? You know, from this promotion to the next promotion, for example. So that is a welcome move by the code. I think very subtle forms of violence and overt violence are definitely covered. But making sure that an employer does it periodically, that there are safeguards, that the Commission plays a more active role, that people are properly trained, that there's no re-traumatization, those aspects I think are perhaps not sufficiently covered.
Okay, and that brings us to the end of this workshop today. Riola, thank you so much. I think that was very informative, and I think by the comments, everyone is just so impressed with the amount of work that you've put in here. I think we have a better understanding of this code. Kopi, okay. If you may, in your closing, if you may just also confirm if people have further comments that they would like to put forward to the BMF, can they email those to you? In your closing, can you just touch on that? From my side, I really thank everyone for engaging. Thank you to the BMF for always providing spaces where we can shape how this country is led and how we can advance ourselves and protect ourselves in where we work and the spaces that we operate in. Tasdim Fredericks, again, thank you so much for always being an enabler. Kopi, for the work that you are putting in. Itu for doing all our admins, the back end, the invisible hand. We really do thank you. And from my side, thank you so much, guys. I will then hand over to Kopi to do the closing remarks for us. Kopi?
But thank you so much to you, Iviwe, to you, Riola, to you, DP, for your presence this morning. You're right, Iviwe, this has been a very informative session. You know, there are some points I've noted from the session myself that make it clear that there are some gaps in this draft. And if you were mentioning earlier that, I mean, considering the kind of country we live in, the kind of trauma we have, the history we have with violence, this is definitely not going to be a draft that's going to be finalized, in the short term. I think it still has a lot of work still needs to be done on this draft, and it's going to be quite a process, because what we want at the end of the day is a robust piece of legislation that makes employers and employees account for the violence that takes place in the workplace, right? So it's long overdue, and in as much as it addresses the previous shortcomings on legislation with regards to violence and harassment in the workplace, I feel there's a lot of work that still needs to be done. And that's something that we will be taking forward and engaging the Commission of Employment Equity on. I'll just have a few questions for you, Riola. So employers in collaboration with workers are responsible for monitoring and the monitoring and evaluation of the policies that they put into place. My problem there is that then who is going to ensure, or what formal structure is going to ensure that they do this in the first place? I feel like there's too much responsibility that's being placed on employers and employees who are not familiar themselves with what is going to be required, not too familiar with what is going to be required of them when it comes to the effective implementation of this. What are your thoughts on that? I know you mentioned that CE needs to ensure, that it plays, a more active role in ensuring that takes place. But what else do you think should be added to strengthen that element of this legislation? And then something else I had noted. Yes. So also the training of HR officials who are responsible for who are going to play a big role in ensuring that this gets implemented. My goodness. So are employers going to be the only ones responsible there? Who else can play a role in ensuring that proper and adequate training takes place for HR personnel that's responsible for ensuring that these new mechanisms are put into place?
Okay, so I'll answer your second question first, and that's my issue with the code as well, where they say that competent HR personnel must be the ones dealing with this. However, the Commission hasn't said anything about them implementing any kind of training mechanisms that are going to ensure that there's a minimum standard that all HR personnel need to know. And I think the Commission must step up in that regard. There's no way the implementation of this legislation is going to be effective where there are people who are unequipped to do so implementing it. And we see the exact same thing happening with the Domestic Violence Act at our police stations. The police are simply not equipped to deal with it. They're not properly trained in the Domestic Violence Act, and so they make violations on a daily basis. Now, that's my concern, particularly where you have small employers who just don't have budgets now, particularly in the great, like a recession, to send HR personnel for this kind of training. Not all HR personnel are industrial psychologists by profession, and so they may not necessarily be equipped to deal with this. Often in small organizations, the HR personnel is maybe even a finance person, for example, etc. And so that's why I'm saying the Commission does need to make some steps in this regard to say minimum basic level training is going to be provided either by the Department of Employment and Labor or by the Commission themselves. And I think that's something the department, if we're serious about eliminating harassment and violence, we must actually build capacity in workplaces, and we must make sure that some minimum standard is set. So often, for example, we can't expect, or some employers may just do an online course or whatever. That's why I'm saying there must be a set standard for what people must know, the bare minimums. That's in my view. So that's the first thing. Then in relation to the drafting of codes, etc., drafting of policies, etc., what the code says is that you must take into account all relevant stakeholders. So the policy must be drafted in conjunction with all relevant stakeholders. Now, this is not just employees and employers. It also includes trade unions, for example, bargaining councils where necessary, other employer organizations that may be applicable, particularly, for example, in the mining industry and the like, where you would have employer-employee organizations or forums, etc. All of those stakeholders do need to be taken into account. I do think that it's important when drafting these policies to in fact have employee input. And the reason I say this is that workplace to workplace cultures differ. And what specific employees may be comfortable with in one workplace may differ in a different workplace because the culture of the workplace is different. And so I do think that employee, at least representatives, must be at the round table when deciding about these policies. And I also think trade union representatives, just because I do think it gives employees a level of protection. So I do think this idea that stakeholders must be involved in the drafting of this policy. Now, if you look at a jurisdiction, for example, like Zambia, or even Zimbabwe, where there's any amendments to disciplinary codes and procedures or any kind of policies, there's two things that an employer must do. One, they must register those new policies with the department. That's the first thing. The second thing that you actually need to show in Zambia and Zimbabwe is that you have engaged with the relevant individuals. Now, this is what I'm saying in relation to the policy that's drafted here. There must be a submission to the Commission in relation to this policy so we can make sure certain minimum standards are required or are met. And there must be some kind of proof shown that either meetings were held with the relevant stakeholders, with the representatives, etc., in the drafting of that policy. And it's not a completely, like I said, it's not an outrageous requirement. Zambia does it, Zimbabwe does it. Mozambique, every time you update the contracts of employment, your standard contract of employment, you need to submit it to the Labor Inspectorate together with proof that you have in fact engaged with the relevant unions. Now that can be emails, that can be minutes of meetings, that can be and the like. And so I do think that the code must also make specific thing that policies must be submitted to the Commission, and that you must show you have engaged with the relevant stakeholders. And like I said, this is common practice across Africa. So it's nothing unusual to expect that of employers.
It only makes sense. And I think that would go a long way in ensuring that employers are complying and in holding them accountable for actually putting this into effect. Thank you, Riola.
Pleasure, and thank you guys for having me.
Only a pleasure. Iviwe, you wanted me to address something. I forgot. Can you just remind me, please?
Yes, Kopi. It's around. I've been having comments. People asking if the presentation will be circulated. So I guess that people who attended this workshop, we can circulate that, if you can just confirm that. And secondly, if there are any further comments outside of this platform and people would like to put forward to the BMF, can they email those to you?
Yes, they can email comments to me, to my email address. It's kopi@bmfonline.co.za. And the presentation will be available on YouTube. And I'll speak to my team about sending the direct presentation to the participants that are here today, but it's going to be available on our YouTube channel for everyone.
Okay, that's all.
So my email address again, it's kopi@bmfonline.co.za. I hope they got that. Okay, thank you so much to all the participants that were here today. I look forward to the additional input that we will be receiving from the membership. But Riola's presentation has definitely assisted us in broadening our thinking, informing us more on what this draft code is about, and helping us consolidate our input, which we will be making next week, Wednesday. So please make sure that you do your best to send your comments as soon as possible before then. Iviwe, thank you. DP, thank you. Riola, thank you. And may you have a lovely day further.
Thanks, Kopi. Thanks, everyone. And thanks, Riola. We know you are presenting all the way from India and that there is a bit of storms happening. So thank you for availing yourself and for being available. We really and truly appreciate it as the BMF. And most of what you said, we definitely will be making input to the Department of Labour by the 21st of October. Thank you so much,
Thank you so much for
everyone.
having me.
Thank you.